And welcome to the Week 8 video lecture. In Week 8, we're going to talk about settlement, negotiation, and remedial measures. These are aspects that involve evidence because there are many policy considerations involved in the process of settlement, negotiation, and remedial measures that will have us excluding evidence that may go on or things that may go on in settlement, in negotiations, or having to do with remedial measures from the evidence that can be presented at trial. This means that we are going to be excluding evidence that might be very probative, very relevant, very important, but because of these policy reasons, we're not going to allow it to be used. So think of this entire lecture really as having everything to do with excluding evidence for policy reasons into these three different given areas. It's important because paralegals need to know what they can say, what they can do, what they cannot say, what they cannot do in a settlement, in negotiations, or regarding remedial measures. And for that matter, everyone that's involved in the law office has to know it as well. So we're going to first study the role of paralegals in settlement negotiations and see how it may be one that requires us to think very carefully about what we can and cannot say, or what we will give away to the other side when we don't want to. And it'll be important for us to be a part of the process of making sure that we don't say things that we don't want to give away to the other side, and nothing be given away that will ever be used against our client for sure. Also, we're going to talk about compromise and offers to compromise, which are a particular statutory thing that is used in the legal litigation system for civil cases, not for criminal cases, but civil cases, where these offers are used as a way of sort of putting pressure on the other side. In essence, if you make an offer on a civil case, you say, listen, I'm the defendant in this case, I offer to pay you $10,000 and make it go away. If the other side doesn't take the $10,000 and they don't do better at trial, there will be penalties involved, including most likely the payment of tremendous amounts of cost of the side that made the compromise offer, such that you could end up losing more money on the case than you will win as a result of not taking the compromise. So that's it's a system, but we want to see that when we make these kind of offers, we don't want to have to worry about whether the other side is going to use that offer against us, because it would certainly be something that would be sort of a consciousness of guilt if we were to make an offer as a defendant to settle a case. When we make such an offer, then we're going to, wonder if it's going to be used against us in trial. We don't want to get our client up on the stand and have them ask, well, isn't it true you offered $10,000 in this case, yet you say you didn't do anything wrong? We don't want that to happen, so we'll see how that works there as well. We're also going to go into when settlement negotiations and agreements are admissible. They are sometimes admissible, so you have to know when they are in order to know what things we can allow a client to say. Very important because, for instance, even though settlement negotiations are not generally admissible in a civil case, they are admissible in a criminal case. So if someone makes an admission in a civil case that is damning against them in a criminal case regarding the same matter, they are going to be in trouble. All right, excludability of evidence of remedial measures. We're going to go into why we exclude evidence of remedial measures, and we can talk about remedial measures. Remedial measures are things that happen because, let's say, an accident occurs. Let's assume you are a business and you have a set of stairs, and someone slips on that stairs, and you go out and look at the stairs, and you see there's a crack in the stairs that was probably why they slipped and fell. And you go out there and you repair the crack in the stairway so that no one else is ever going to slip. Well, if we didn't have this rule that excludes the evidence of those remedial measures of actually fixing the steps, then people probably wouldn't fix them. And the reason why they wouldn't fix them is because they know that it'll be used against them in a trial. Well, we don't want people slipping more than once on something that shouldn't be slipping on. We don't want more than one person to get hurt. So as a policy, we're going to say, no, you cannot use remedial measures in a civil case to prove liability or negligence. So there you go. Now you can go ahead and fix everything up, and they can't use it against you. Okay. All right. So let's continue on. We're also going to go into payment of medical and similar expenses. Sometimes we actually offer to make payments of medical expenses to people, and there can be lots of reasons why we do that. It may have nothing to do with whether we did anything wrong, but just because it was a bad situation, and maybe we think that the person needs the money and wouldn't get the medical care that they need otherwise, and we feel like it's a sad event, and we just want to pay the medical bills. Well, if we didn't have rules against that being used against us, then we would not be getting people paying other people's medical bills, which is not necessarily a good thing. And so we've got to make sure that we have rules that allow anybody who pays a medical bill or similar expenses of someone involved in an accident isn't going to have that used against them later on, or they just won't do it. Also, we're going to get into the exclusion of evidence of liability insurance because, it'd be nice in a trial if we could say to the jury, well, by the way, this defendant here has a $10 million policy of insurance. Well, that would make the jury maybe want to award more money because they think there's a big pot of gold that's not going to come out of the pocket of the defendant if they award it. Well, that's not how we want them to think. We want them to think that they will award money only if there is negligence and there's been real damages that the person should pay for, and not because they have an insurance policy. Nor do we want to have it that there's no insurance as something the jury knows about, because then they might not want to award as much as they would normally award in the case, because they know it's going to come directly out of a person's pocket, for instance. So those are things we have to make rules so that those things don't come in. Also, we're going to get into the exclusion of evidence of unaccepted plea bargains, withdrawal pleas, and no contest pleas. Because what can happen is you could be in a criminal case, and there can be a civil case associated with it. Let's say, for instance, you were involved in an embezzlement, and you were criminally prosecuted for embezzlement. Well, the people who had their money embezzled will probably sue you if they think you have any money, and so your plea in that case could possibly be used against you in the civil case if it's the right kind. But there are certain kinds that we just don't allow to be used for many different reasons. This will go over when we get into that section. All right, let's look at settlement, negotiation, and remedial measures in particular, but let's look at paralegals. They are extensively involved in settlement negotiations and the settlement agreement. There are many details to take care of. There are agreements to make up. There are trial briefs to make up. There are settlement briefs to make up for the court. There are talking to the client about what they can say, what they can't say, that kind of thing. So they will often prepare memorandums summarizing the client's case. They will be involved in negotiations in particular, and they will often be preparing settlement agreements, often from forms that are available in the firm's form file. Also, settlement negotiations invariably result in admissions being made by both parties. What that means is there'll be something that is said by the parties because they want to talk frankly about the case. And they don't want to appear like they're just an obstructionist if they're really trying to settle the case. So they want to maybe admit, oh yeah, I could have done better on this, this left turn I did, and that caused this accident. Well, that kind of thing could be used against you if there was a trial regarding negligence. If you believe you could have done better, then it's a pretty good idea you probably were negligent. Well, we don't want those kind of things to be used against people who are involved in settlement negotiations, because if we did, no one would be involved in settlement negotiations. And as it is, about 98% of civil cases are settled through negotiations in one way or another. And if it was not for settlement negotiations, that would not be the case, and the court system would fall on its face tomorrow, because there would not be enough courts to try every case. So we do want to encourage settlement negotiations. We do not want to discourage it, but I guarantee you, if we didn't have a rule that said that we will not use what's said in a settlement negotiation against a party in the action, there would be little or no settlement negotiations at all. So again, admissions will be often said on both sides that will be damaging to their client's case. Statements about the quality of the client's case can also be damaging. They may say, well, yeah, it's possible I may not get as much as I'm asking here in my settlement negotiations at trial. That's a damning sort of admission that maybe you're asking for too much. And that would be used against you at trial. When you ask for that much at trial and you admit that maybe that was too much, well, the jury's going to think, well, then maybe we shouldn't give you so much. We don't want that coming out either, because otherwise people can't talk frankly in the settlement negotiation. So let's look at the specific rule. Federal Rule 408, there are similar rules in California. It prohibits the use of statements and offers made during compromise negotiations and settlements when offered to prove the validity of a civil claim. And underline the word civil, not criminal. In essence, it's often regarding the validity of liability itself. It's also perhaps validity of the amount of damages that you're asking for. It also prohibits the use of statements during negotiations as prior inconsistent statements at trial. So, for instance, if you say, oh, I think I was perfectly rightful in everything I did, but you said something in settlement negotiation indicating that you might have been negligent, we do not allow that statement that you use in settlement negotiations to be used as a prior inconsistent statement at trial, because the same thing would happen if we allowed that. No one would be involved in settlement negotiations. All right, so this is created for public policy reasons to encourage settlements. It's created to save money for society by encouraging more settlements. And there's even an additional rationale, and that is the settlement or offer of settlement has little value in actually proving which party was at fault or who owed money to whom, because after all, the parties themselves are not very good judges of whether they have a claim or defense. The jury is the best at that, of course. And so really what they have to say isn't really so important. So that's another reason involved. All right, so when are settlement negotiations and agreements admissible? Because there's a general rule. In civil cases, they are not admissible. Well, let's go over the reasons. If you give away trial theories, tactics, availability of evidence to the other side, then the other side can use this information against you. Now, what this means is, let's assume you're talking to settlement negotiations, and they say, well, you don't have any evidence that this person was negligent. You have no such evidence whatsoever. And you say, oh, yes, we do. And I'll tell you exactly what it is. Well, if you do that and the other side didn't know about that evidence, well, they know about it now. And you can't take that away from them. It's done. You can't unring that bell. And so any trial theories of the law, for instance, that they may have been ignorant of, tactics that you're using that might be something that they should be protecting themselves against but maybe didn't, and the availability of evidence these are all things that you do not want to discuss in settlement negotiations, no matter what. So if they try to bait you into talking about, what evidence you have, what trial theories you have, what tactics you have, just say, you know what, we're not talking theories, tactics, or availability of evidence in our settlement negotiations. We're just going to talk, hopefully, frankly, about what the case is all about and see what we can do about possibly settling, but we're not going to talk about those things. We're just not going to do it. Also, no exclusion of evidence collected as a result of information exchanged in the settlement negotiation. So there's no exclusion of evidence that was collected as a result of the information that was exchanged. So if they get a hint from whatever you're saying that there's evidence that they could go out and collect, and they go out and they collect it, then too bad. If you gave them a hint that there might be evidence, maybe you gave them a hint where it was, that's not going to work. You're going to get that one given away. There's nothing you can do to get it back. Paralegals should be involved in negotiations only to the extent of disclosing information that the other side has or will have for certain at the time of trial. So that means that we can give them away everything we know they're going to have. If we're going to give it to them anyway, if we know they're going to get it, then we're not really losing anything. But if we're not going to be giving away anything that they might not ever get, no matter what, even if it's because the lawyers on the other side are not doing a very good job, we are not going to sell our client down the road because we want to facilitate the settlement. No, that would be a violation of our duties to our client. It would be a big mistake to ever do. So you as paralegals don't ever want to be involved in that. So paralegals have to understand that they will not talk about anything that is not already known by the other side, really. Let the attorney decide on what information that they don't already know should be disclosed to them in settlement negotiations, not you as the paralegal. You don't want to have to explain to your boss why you gave away something that you shouldn't have. All right, let's look at Rule 408A2 in criminal cases. And then that is conduct or statements made in compromise negotiations regarding the civil claim are prohibited except when offered in a criminal case and the negotiations related to a claim by a public office or agency in the exercise of regulatory, investigative, or enforcement authority. So as a practical matter, what this A2 rule says is that there's an exception to the general rule, and that is that conduct or statements made in compromise negotiations regarding a civil claim would normally be prohibited from being used except when they're offered in a criminal case or even something regarding a claim by a public office or agency involved with the government. Okay, so there it is. There's your exception. And this is where there can be some real trouble. If there's either a pending criminal case against our client, or there's a possibility that there could be one filed against our client for whatever they did in a civil case, we probably don't want to get involved in settlement negotiations, or at least we don't want our client to say a word in those settlement negotiations, ever. They should be completely silent, because whatever they do say, literally, can be used against them. And there's no Miranda rights. They're not going to be warned that there's a problem if they start talking. Because once they start talking, we can talk for them, and that doesn't get imputed to our client. But the client cannot talk in those kind of situations. All right. For reasons other than to prove the validity of the claim, we can use the information also. If we want to use it to prove a witness's bias or prejudice, or to negate a contention of undue delay, or to prove an effort to obstruct a criminal investigation or prosecution. Let's get some examples here to give you what this is all about. It's possible that whatever was said in negotiations may show that a witness is biased or prejudiced. So it could be that you might find out that a witness, for instance, is a relative of the opposing party. Well, that admission could be used against the witness, not necessarily against the party, against the witness to show their bias or prejudice in the case. Another one, it's sometimes what happens in these kind of cases is there are extensive settlement negotiations, sometimes before we even file the case, and even sometimes before we file the case and after we file the case. So it could be that if you ever get to a trial someday, it might be 2 or 3 years down the road. And so if the other side makes the contention that there was undue delay in bringing this claim because now it's 3 years down the road, wait a minute, we're gonna start to use all of the settlement negotiations we were involved with the parties in order not to prove that our claim was valid or our defense is valid, but to prove why there was a delay. See? So we can use it for that purpose. So we don't want to bring up an undue delay based on settlement negotiations, because then we're opening up the door to whatever was done in the settlement negotiations. We don't want that stuff coming in. It's also could used to prove an effort to obstruct a criminal investigation or prosecution, which just means that if it's going to be used in a criminal case, there's no rule that prohibits it from being used in a criminal case. So it's possible, for instance, that you might have negotiations where someone says, well, there's a possibility I could be prosecuted for embezzlement in this case. So if I pay you, you must agree never to report this crime to any governmental agency or police department. Well, if that happens, that effort to obstruct criminal investigation or prosecution could be used against the criminal defendant in the criminal case, and will be. So that's just another example of where that can happen. Also, Rule 403. All attempts to get into evidence, settlement negotiations through the back door are subject to being excluded for being more unjustly prejudicial than probative. So if we can figure a way to get this stuff in under some other theory other than the ones we already talked about, probably it's going to be kicked out for being unjustly prejudicial, at least more unjustly prejudicial than probative. Okay. All right, let's look at remedial measures, because that has to do with settlement negotiation. That's basically it. We have a rule that says you can't get it in a civil case, except under certain unusual circumstances, but you can get it in a criminal case. That was very important. Now, remedial measures are measures taken to change a product or a thing after an accident to remedy or fix the problem. So if somebody gets hurt because of something, let's say if we have a product, let's say, and somebody gets hurt because of that product, then if we go out and we fix that product and we now start putting it out in a different form, The other side could try to use that as a basis for proving that the product was defective in the first place. Well, we don't want that to happen, because if we do, as you can see, people would be reluctant to want to fix the problem, and more people would probably get hurt. So the general rule is, as FRE 407, it says if a person takes remedial efforts to fix a product or dangerous condition after it has caused injury, evidence of such remedial measure is not admissible to prove liability. Now, by the way, if it's used to prove something other than liability, it's outside the rule. So watch out. If it's used for something else, if you can figure a way to use this stuff for some other reason, you're going to be able to allow it in. So if you can prove bias or prejudice, all that kind of stuff. All right. Exception is remedial efforts have been found to be admissible to prove a defense that precautionary measures were not feasible. So, for instance, if this is, let's just, I'll give you an example that makes this thing understandable. Let's assume you put out a product. There's product's liability, as we know. If it's defective, you're going to have to pay for the damage that it creates. Okay. Well, you have someone who gets hurt with your product. You get sued. Now you're the defendant. And one of the things you want to say is that, well, it's not really defective because there's nothing more we could have done here. Anything that you want to mention that could be done to make this product more safe is not feasible. Okay? If you take that position as a defendant, and then you go out and you actually fix the problem, watch out, because then the remedial measures are going to come in against you, because they're going to not prove liability. They're going to prove they're going to disprove your defense that precautionary measures were not feasible. They're feasible because you did them, and therefore it's a good evidence to thwart your defense that you made up, and obviously was not a good one because it didn't work. And so you're gonna give up that protection of Rule 407 if you have that defense of precautionary measures were not feasible. Okay, again, so watch out if you're going to have one of these precautionary measures are not feasible defenses in a product's liability case, because you're likely to find yourself in bad trouble if you actually did fix the problem. All right, let's look at Rule 409. That's payment of medical expenses. Again, you go into an accident situation. You can, you may not think you were negligent in whatever happened, but you may know somebody may not get their medical bills paid. Maybe they don't have an insurance, and you just out of sympathy, you pay their medical bills, and hope that they are grateful for that, even though you didn't do anything wrong. And that's one of the reasons why payment of medical expenses is not going to be allowed to be used in a trial to prove liability, is for that reason. So Federal Rule 409 says evidence of furnishing or offering or promising to pay medical, hospital, or similar expenses occasioned by an injury is inadmissible to prove liability for the injury. If we didn't do this, no one would pay the medical expenses of anyone. No one would do what they think is just the right thing to do. They would walk away and say, you're not getting anything from me, because if I do that, you're going to use it against me. Also, insurance companies will pay medicals on cases where liability is questionable. Why? Because, well, most of the time people will go away. If you pay their medicals, they'll just go away if it's questionable, especially. And so it's an incentive just to pay the medicals and make the people go away. And so if we know that people won't help each other if they regret it later on, then we have a rule that will prevent them from regretting it, because it will never be able to be used against them. Okay, that's very important. All right, let's look at exclusion of evidence of liability insurance. Rule 411, evidence that a person was or was not insured, it's both ways, against liability is not admissible upon the issue whether the person acted negligently or otherwise wrongfully. So, what this means is you cannot bring in evidence that a person is insured. You cannot bring in evidence that they are not insured in a case involving negligence or some sort of wrongful conduct. The rationale is that virtually has no probative value and is highly prejudicial. Juries will tend to award a lot more money if they know that the person has a liability policy. They also will tend to not award as much as they should in a case where the person does not have a liability insurance policy. And so because of that, it is just absolutely so prejudicial and has so little probative value, if any probative value, that we've excluded it. We're just not going to allow it to happen. This is, again, in a civil case, not in a criminal case. But it's good enough for keeping this out of the hands of the plaintiff. So know that there are some times where we can kind of sneak it in For instance, in jury voir dire, where we ask jurors questions about whether they can be biased or unbiased in the case, we might ask them whether they have any interest in, or anybody that's close to them has any interest in, the ABC Insurance Company. And of course, the reason why is because we don't want anybody who's involved in that insurance company to be in the case because they might know about the case. But in reality, we're actually suggesting to them that there is an insurance policy. That's one way we get around it a little bit. And that's been allowed because we certainly don't want someone from the insurance company who's involved in that case to be a juror, because again, they may have interest. They may have not only interest, but they may also have knowledge of the case that they're not telling us about. All right, that's it for these rules for settlement negotiations and remedial measures. All right, so these rules are important for you to know and to outline and have available, and you'll do well on the quiz. Again, if you have any questions, please feel free to give me a call.